Thank you for staying with us on Citizen Weekend. And to set the stage for that conversation with Charles Kanjama, Senior Counsel on protests and the law, 36 Kenyans were on Thursday charged with terrorism at the Kahawa Law Courts for damage done to government facilities on the 25th of June. 26 have been charged with terrorism, arson and malicious damage to the Kikuyu probation offices, Kikuyu Law Courts, Kikuyu Sub-County offices, Kikuyu Chief's Office, the Office of the Registrar of Persons, Kikuyu Sub-County Education Office, the Sub-County Accountant's Office, Registrar of Lands Office, Dagoretti Police Post and the Kikuyu Deputy County Commissioner's Office. In their number are Democracy for the Citizens youth leaders Wanjiku Thiga and Peter Kawanjiru. The other 10 are accused of committing a terrorist act at the Matu police station, leading to the destruction of government property, including police vehicles. Meanwhile, the Manyatta Member of Parliament, Gitonga Mukunji, journalist and Boda Boda rider are also under investigation for terrorism over the Saba Day protests.
And these are political terrorists. It was terrorism disguised as dissent.
Those who attack our police, those who attack our security men and women, those who attack our security installations, including police stations, that is a declaration of war. That is terrorism. We are going to deal with you firmly.
This narrative you are creating that there is an attempt to overthrow your government is for you to have the opportunity to use a terrorism act to profile communities and to persecute leaders who are opposed to your administration. Please relax. We want you to serve your one term.
All right, Charles, karibu sana.
Thank you.
How does the Constitution define terrorism? The law, I beg your pardon, the law.
Okay, so first, let me say that the Constitution doesn't refer to terrorism. It only refers to fundamental rights and freedoms, which includes freedom of assembly, freedom of protest, and so on. So the offenses are defined mainly in the penal code. These are ordinary offenses. There are other acts of parliament that also define offenses against public order, like the Public Order Act. The Prevention of Terrorism Act is a law that was enacted by Parliament in 2012, 2 years after we got the new constitution. And the Prevention of Terrorism Act begins, like other laws against terrorism in other countries, by saying that a terrorist act involves an act that already constitutes another offense. So it's like you've committed a criminal offense. But this criminal offense, you're committing it with an intention to cause, to coerce the government to do something, in other words, to intimidate the government, or to cause terror, which means general fear among the public. So you're doing it for a reason that could be political, religious, or other reason. It's an ideological reason. So terrorism basically is a criminal act like injury to a person, damage to property. It could be things to do with weapons. It could be things to do with chemical weapons or other actions of that nature. But the purpose is to cause damage, to cause fear, to cause general fear, or to compel the government to do something that it's not meant to do. If I can just very expressly read the definition in the law, it says, an act which involves the use of violence against a person, endangers the life of a person, creates a serious risk to the health or safety of the public, results in serious damage to property, involves the use of firearms or explosives, involves the release of any dangerous, harmful, toxic, or radioactive substance, interferes with an electronic system, resulting in disruption in provision of communication, interferes or disrupts the provision of essential emergency services, prejudices national security. That's the action. And then the second element is, and that action is carried out with the aim of intimidating or causing fear among members of the public or a section of the public, or intimidating or compelling the government or international organization to do a certain act, or to refrain from doing a certain act which they are entitled to do, or which destabilizes the religious, political, constitutional, economic, or social institutions within the country. So basically, terrorism means you cause harm, a criminal act, against a second person with the intention of causing a group of people, the third group of people or government, to act or not act in a certain way.
All right. So previously we've seen terrorism used where Al-Shabaab actors are concerned, for instance. We most recently not really as recent as that, but in the Shakahola case, there was, when Kithure Kindiki was the Interior Cabinet Secretary, he defined it as terrorism, and they were charged with terrorism-related charges. Is this the first time we are seeing it applied to a political context? And I say political because Murkomen's words were, this is political terrorism.
Okay, so let me start by saying that there is no accepted international definition of terrorism. But there is a general consensus that terrorism involves extremism. It could be a radical extremism that is driven by religion or ideology. The political motivations, normal, competitive, or partisan politics are not meant to be included in the definition of terrorism. Even in our Prevention of Terrorism Act, it has a caveat. It says, provided that an act which disrupts any services and is committed in pursuance of a protest, demonstration, or stoppage of work shall be deemed not to be terrorism, unless, of course, it causes widespread injury to people or damage to lives of people, and also causes widespread fear. So even in the drafting of the Prevention of Terrorism Act, there was a realization that terrorism can be misused as an offense to hit out against political opponents. And the act has tried to carve out situations of politics not to be terrorism. In the case of Kenya, the previous experience with the Prevention of Terrorism Act was for actions which we all understood involved extremism, wanton destruction of property, targeting innocent civilians like Al-Shabaab, Garissa University, and so on. So this is a new development by which the government is now trying to use the Prevention of Terrorism Act to go against protesters who are engaged in mobilization against the government on political grounds. Mm-hmm.
In 2024, what we had, the term that was used to define what we witnessed then was treason, that these are treasonous acts. Now we hear terrorism. So is this precedent setting? Will the charges that have been filed against these 36 individuals, are they precedent setting the case itself?
Okay, first let me say treason is under Section 40 of the Penal Code. It's an offense that's been there before Kenya became independent. It's a standard offense in most penal statutes of different countries. It's about trying to overthrow a government using unlawful means. Terrorism is going beyond. You're saying it's like you're engaging in treason, but you're also causing widespread fear, paralyzing the countries, like you're causing terror. So in this particular case, the government is trying to use new instruments or tools that it has been given by Parliament in 2012, which is the Prevention of Terrorism Act, as an attempt to quash the widespread destruction of property or or could say the sentiment of the public that has gone beyond just the sentiment into causing injury or harm. Because there are people who are masquerading as protesters, they were goons and they caused injury. Whether those goons came from one side or the other is not what we are discussing right now. The problem is there's so much potential for abuse of these provisions in a charge sheet related to the protest, because you go against people who the government may be targeting for political reasons, to pass a message that it's not right to protest against the government, and everyone has a right of protest. So I think it is a new thing that the government is trying, and we'll all watch to see how the courts interpret the law, how the lawyers who are defending the accused deal with the issue, and eventually what interpretations will come to guide future application of the terrorism law in situations of this kind.
All right. So if you look at the statement that was posted by the Office of the Director of Public Prosecutions on Thursday, when they list the facilities, the facilities that were destroyed or damaged during the June 25th protests, they're all government facilities. Same thing in Kikuyu, Matu. So, you know, what do you make of that? That they didn't necessarily list Naivas and Magunas, or, you know, they listed the education office in Kikuyu, the law courts in Kikuyu, the police station in Kikuyu. What are your thoughts on that? Okay,
two things I would say. First of all, unlawful damage to property in these situations is already an offense called arson that is in the penal code, and it would have been much easier for the government if they have evidence, or the police and the investigating agencies, to consider charging the people with a crime like arson, and the DPP would find it easier because you just prove the guilty act and the intention to cause injury. That's all, and you'll be able to prove arson. In this particular case, they need to say that you are not only intending to cause injury, but you went further. You had a higher intention to cause terror to the population at large, or to compel the government to do something which was unlawful. That's the first thing I would say. The second thing, in answer to your specific question, is that when you draft a charge sheet and you go to court as an investigator or the prosecutor, you have to put there the material facts relating to the accused person. So if you've arrested accused person who has touched, for example, Kiambu law courts, not Kiambu, Kikuyu law courts, you cannot put in the material facts what happened in other parts of the country or other properties that were touched, unless you get someone who was involved in arson to that other property. So my explanation is that probably the government believes it has got suspects who were involved in injury to government properties, but they have not got any suspect who was involved in injury to private property. Of course, there are those who are claiming that some of these goons were facilitated by pro-government figures when they were causing injury to private property, and maybe that is why they were not arrested. But that is speculation. Right now, I do not have the facts about the issue. What I can say is that the government seems to be confident they have arrested some arsonists in relation to public property, and they want to escalate the charge beyond arson to terrorism.
All right. So there are those who have raised questions around why, when it comes to the government facilities in Kikuyu, the charge is, in addition to arson and damage to property, destruction of property, is terrorism. And then they draw a parallel. They say, but when we talk about the Mawego police station, as much as there are custodial orders and the police have asked for custodial orders for further investigations, they're saying the view there is arson. So is it because now the government is saying they can prove that these actions, this arsoners, if the arson is proved, that had the further intention of causing terror?
It's actually a much bigger challenge to prove that further intention of causing terror. And the government will really need to have a strong evidence because this has to do with the second element of crime. Every crime must meet two elements. The first is what we call the guilty action or omission. You did something or you deliberately fail to do something that you are responsible for doing. That's a guilty action. The second element tends to be the more difficult to prove, which is a guilty intention. So the guilty intention, if it is damage to property, it's easier to prove a guilty intention of you intended to damage this property because that was a natural consequence of what you are doing. But to prove terrorism, you need to show that the person intended to do much more to cause you could say, terror among the population of the country. How would a person maybe burning a police station in Kikuyu or somewhere, or court, cause terror among such a large number of people? You understand? So what they normally do when they're trying to prove terrorism offenses, if it is a group that is associated with that action, they're able to show the philosophy of the group, the publications of the group, what the group has done in the past, because these are organized groups. And if it is individuals who may not be associated with a previous group, maybe the person had done some writings, they had said, the reason I want to, I don't know, cause this terror or go on a rampage of killing is because of ABCD. So you bring out the question of the terroristic intention, not just by assumption or presumption, but by demonstrating through cogent evidence that this person wanted to cause that terror. From what I have heard in this particular situation, I have not seen that kind of evidence myself. But when the prosecution present that evidence to the defense side, we will see whether they actually have evidence of that kind. And maybe they're just testing the law. They have charged with arson, and they've also added terror to see whether they can test the law and get a conviction. Under the Prevention of Terrorism Act, normal acts of terror, if I can say normal acts of terror in quotes, the maximum penalty is 30 years. And then if you are involved in facilitating, you are not the terrorist, but you are facilitating terror of someone else, the maximum penalty is 20 years. But if you get involved in an act of terror that is aggravated, it results in death of someone, then the maximum penalty is life imprisonment. So I don't think there is a great significance in terms of the maximum penalty if you charge someone for terrorism, or you go and charge for arson or murder, manslaughter, etc. I think they're just sending a signal or a message that this is more serious. Maybe they want to keep the people behind bars without them getting bail, pending trial. There are many possible reasons why the government has chosen to use the Prevention of Terrorism Act.
All right. Thank you for speaking to us on Citizen Weekend. Charles Kanjama, Senior Counsel, Constitutional Lawyer. We take a break on Citizen Weekend, but stay tuned.